Today's aims are to consider the meaning of personal welfare, the character and creation of a health and welfare lasting power of attorney, attorneys who may act as an attorney, the choice of attorney and the duties of attorneys, instructions and preferences, giving or refusing consent to life-sustaining treatment, interaction with advanced decisions to refuse treatment, revocation of health and welfare lasting powers of attorney, decision-making in the absence of a health and welfare lasting power of attorney. Section 10 of the MCA provides that an attorney of a health and welfare LPA must be an individual who has reached the age of 18. Trust corporations cannot be appointed as attorneys under a health and welfare LPA, unlike with a property and financial affairs LPA. An individual who is bankrupt or is a person in relation to whom a debt relief order is made may not be appointed as an attorney under a property and affairs LPA, but there is no corresponding restriction in relation to health and welfare LPAs. Similarly, the provisions of Section 13 of the MCA that result in the termination of an appointment under an LPA in the event of the bankruptcy of the attorney or the making of a debt relief order in relation to him or her are subject to the proviso that this does not terminate his appointment insofar as his authority relates to the donor's personal welfare. There may be circumstances in which an individual is or becomes bankrupt or becomes subject to a debt relief order, but is nevertheless the most appropriate person to act or continue to act as an attorney under a health and welfare LPA, for example, the spouse or civil partner of the donor. The maximum number of attorneys that can be appointed under an LPA is 5. This restriction applies equally to both forms of LPA. Where more than one attorney is appointed, Section 10(4) of the MCA provides that the instrument may appoint them to act jointly and severally, or jointly in respect of some matters, and jointly and severally in respect of others. Where there is doubt as to whether attorneys are appointed jointly or jointly and severally, Section 10(5) states that the instrument is to be assumed to appoint them to act jointly.